Welcome to Chapter 1, our first show. I'm Judge Not Lesty. And just a little background here to make sure you understand I am not anymore a Superior Court judge. I was, and then I retired. I was not a full-time judge. I was a part-time judge. I always have to throw that in. But I'm going to talk about sovereign citizens and why their current method of trying to make change will not make any change and will not ever result in them not going to jail or not getting punished. It will always result in them being punished. And then I'll tell you why I would do that if I was their judge. I've never had one because I retired before they came out. But when I tell you this is what I would do if I was still on the bench, you can hear what you would do to avoid the consequences and make your actions a little bit more beneficial to you so that you actually do get something out of it. But you have to understand a couple of very basic tenets, and these are the things that I'm going on. And the first and foremost one is you're not going to bull the court. Just not going to happen. I saw one of the biggest episodes today of a gentleman who pulled the, I want the judge recused and the sheriff recused and everybody recused. I want everybody in the audience of the court recused. And when the judge said, no, I'm not doing that, and I am getting ready to sentence you, this man today, this young gentleman, said the words that he will regret the rest of his life. Now, he didn't know it because he was representing himself, but if he'd had an attorney, he certainly wouldn't have said what he did. What he said was, well, Your Honor, I only filed the papers in federal court just to, put my foot on your neck. I just was trying to pressure you into giving me what I want. So now that you know that, Judge, would you just give me what I want and let me go? And the judge, who's not a very good judge, I'll name him later, but the judge is not a very good judge, at least called that one right and said, no, you don't get to do that. But what the judge really and truly missed out was that he should have, from the very beginning, used the judge not method of stopping the sovcit. And we'll go into that right now. Okay, when the sovcit comes up and I call the name of the defendant as it's listed on the criminal complaint, I believe most people know that I have in front of me, or I had in front of me, a complaint which is maybe 3 pages, sometimes 12 pages, but it's got quite a few mentions of the defendant's name, and I'm instructed by the little book next to me to call the name and see if that person is there and make absolutely certain that the person who's at the podium answers up. Because we don't want any appeals later about, oh, no, I got mixed up, that wasn't me. So that's really the danger. That's what the judges are looking to avoid. So I just asked them, are you Mr. Schmoozle? And when they start the line, and you know which line I'm talking about, they answer with, I am the citizen of, I am the trustee, I'm the beneficiary of the trust of the, and they start to go on, I just stop them right there. And I would suggest every judge in a similar situation do that. That is the best way to handle this. And what you're doing is you just stop him right there and you say, sir, I am only going to have the court spend its time on the case of this gentleman here. So you are going to admit you are that person, or I'm going to send you out of here as trying to impersonate that person and issue a bench warrant for his arrest for failing to appear today. Now we're going to use the term FTA. That's what the failure to appear is. It's a very common term. So when you hear FTA mentioned by me without explaining what it is, that's what it is. So anyway, that's what I tell them. And now, of course, if you are a SovCit, I know what you're saying. So okay, I'll just go right into the. I object to the court's jurisdiction. The court has no jurisdiction. How could the court have jurisdiction when this is not common law? It's admiralty law. Now, to any SovCit, I will just tell you that is ludicrous. It makes no sense, and it has no legal effect at all. You could say that 1,000 times, and 1,000 judges, different judges, would say, that doesn't make any sense. You're just talking nonsense. But to the judges that are listening to this, remember, your job is to get that guy out of there, or woman, and get them to scoot. And there are a lot of reasons for that, but the main reason for that is that they are a danger to our society. And having them sit there or stand there on the podium enhances and enlarges the amount of danger they are. So I tell them at this point that they have one last chance to either make a phone call or get out of the phone booth. They're either going to admit they are that defendant and participate further under the rules of the court, or if they're not going to admit that that is them, or even if they're going to admit that it's him, but they are going to not participate in the hearing, I tell them, well, if you really believe that you are not under the jurisdiction of this court for the reason that somebody is a corporation and that all the lawyers and judges are actually pulling a scam on you, if you really believe that, well, show that you have the courage of your convictions. Walk out and just say, this court has no jurisdiction over me. Walk out, and I will do what I have to do to show that I have jurisdiction over, and I read the person's name. And I say, I have total jurisdiction over that person. I have the ability to have the biggest gang in town, which is the sheriff's department, go over and pick this person up and bring them in. So you have the chance, sir, to either show me that you really believe that you are not under the convictions of this court and just walk out. We'll take care of it down the line. Or if this is just a scam you're pulling and you really don't know how it works, and I will just really promise you that I've read all of the things about admiralty law and that there's no Social Security, that it's being taken and it's crazy. What you have is a theory that I would be willing to bet is generated by a mentally ill person. And mentally ill persons can spout that kind of stuff. That's what they do. That's what makes them mentally ill. And so they can come up with these convoluted theories about Social Security numbers are a plot by which the government gets your property and whatever it is. All of that stuff is A, not true, B, not possible, but most importantly, it doesn't even make sense. And if it makes sense to you, you should see a doctor. If the doctrine of SovCit, if you've read it, and to you it makes sense, you should see a doctor, because it makes no sense to any person who is not mentally ill. I'll say that again. the theory of SovSit, with the lawyers and judges are in some sort of group where they are passing secret messages to each other and secret payments to each other, that's crazy. If you believe that, you are mentally ill, because if you are not mentally ill, you would see that it's not possible that that could happen. How many people would have to be in on this scam if that were true? Well, somewhere somebody would say, hi, I went to the meeting last night and all the lawyers and all the judges, and they was all there and they was swapping money. Although nobody ever says for what reason. But that's the thing. People who are not mentally ill look at a purported scheme and try to see how many people would have to hold the scheme up, go with it and abide by it in order to keep the scheme working. And that is, we'll get into that when we get into pyramid schemes, but that is the problem. If you don't immediately see that the SovCitizen, and I'm talking now to SovCitizen trainees, applicant people, Moroccan, if you don't see that the explanation, better word is the theory behind sovereign citizen would be impossible, because it would depend on too many people being completely quiet and not speaking the secrets, then if you can't see that, then you have mental problems and you should go see the doctor. All right, to the judges we're going to get back to now. I want to just spend the rest of the time, I don't have much time left, on how the judges should handle this. And I'm not going to get far. I'm only going to get to the beginning. But again, we've had the gentlemen, it seems that it's almost all gentlemen, come up, and he has refused to give his name, and he started the litany about, I am the trustee of the beneficiary of the trust, and the blah, 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 blah. If there's time left on the clock, I see that it does go a long way to say, sir, the trust, what is the name of this trust? Now, he will start to steer away by saying, I don't have the name, but it's the Fed. Then you just bring him right back and say, sir, when I ask you a question, you either answer that question or you say, I don't know. And the most important restriction, explanation you're ever going to give that person is this one. Sir, do you remember when you asked, usually the last hearing, that you asked for permission to represent yourself in this courtroom on this matter, and I granted it? Well, sir, I want to jump to the objection. Sir, be quiet. If I ask you a question, you answer that question, and then you be quiet. And you do not start speaking unless you're recognized by me. It's important that you understand, no matter what you see on TV, this is not a conversation. We are not going back and forth and I'm saying my part and you're saying your part. That is not the way it works. I speak, and then there's silence. And you want to speak, you might raise your hand and I'll look at it and see if your speaking works into my time that I have left to litigate your case, get it through, and get the rest of the cases before the end of the day. But you do not speak without being recognized first. And no, you do not ask to be recognized. You can just signal with your hand up, or you can just wait and not speak. But you do not have the right to speak. Now, I know I've seen at least 50 of these demonstrations, we'll say, where when you tell somebody they don't have the right to speak, they've been taught by the SovSits to break that and say, well, what about the fact that I don't have to come up with anything and start speaking again? What about and to the judges here, the answer is you have to cut them off right there. If you answer that question, you've lost for today. Go home. You don't answer that question. You have to let them know that answering questions or asking questions following being told to be quiet will result in them being subject to contempt. So that's very, very, very important. You have to let them know that when you're speaking, they are subject to contempt if they speak without permission. But we're going to get back now to the most important thing you ever have said to them. And you say, do you remember, sir, when you applied for permission to act as your own attorney, I gave you certain conditions. And one of them was, and we went over how important it was, that you will conduct yourself with the same candor to the court, to the same courtesy that you have seen other attorneys display towards the court, to the court. And again, with the same competence as attorneys. And that means you made me a promise in order to get me to grant you permission to represent yourself on this case, that when you came in here today, you would know the rules that attorneys are bound by. And all the attorneys every day. And I mean, if anybody, and I've never seen anybody of your ilk come in here and just sit and watch attorneys and see how they practice, because that would teach you what it is that you're doing wrong. But you have to know when you come in this afternoon, you have to know how is an attorney obligated to behave before the court, or they will be sanctioned, possibly monetarily, possibly worse. So, I remember one time that I knew that the judge and I had gotten off on something, that we were fighting back and forth, and the judge said, I'll see you back there at 1:30 and we will go over this. And I knew this was going to be trouble. And so when I came back at 1:30, I had my toothbrush in my pocket of my suit. And she saw it, and she kind of like looked, and and that just calmed everybody down, because she knew I was saying, hey, dude, woman, you want to send me to jail, put me in jail for what I just did, defending my client? Go ahead. I brought my toothbrush, I'm ready to go. Every good criminal defense attorney has gotten at least one or two, and usually 10 or 12 situations where they're being held in contempt by the court. Remember, all of the judges are former prosecutors, so they don't like you if you are a defense lawyer. They hate you. I had a guy at the bar come out and tell me, a prosecutor for the bar, come out and tell me, I hate criminal defense lawyers. And I felt like saying, you're mentally ill. But I didn't. And luckily in the case, I was in some trouble. And I pointed out that actually the person that had done the evil was him. Yes, the prosecutor had done the evil. But we're going to let's get back to court. And in the court, if you're the judge, when the defendant comes in there and says, you go for the second time where you say, look, you either admit you are Mr. Shmuley, or if you don't admit it, I'm ending the case right now. And when he starts to go into the long rant, you have to just stop and say, sir, I'm not going to listen to the rant. I'm going to just end today's hearing and rule that you didn't show up, and we'll have a hearing in the future for Mr. Shmuley, and we'll just see what he's going to get in the way of jail time, if any. That usually sobers them up. But if it doesn't, the next thing they're going to take, and this is just a classic, I've seen it 100 times, is they're going to drop in the old, what about your oath? Where's your oath from? Is your oath from and you have to not explain it. That's what that awful judge on TV that everybody thinks is great, but he's the black judge who's, laid back, but he talks to these people when he should be sending them on their way and keeping the court's business expedited. Keeping the court's business expedited is up there in the top 5 functions of the judge. So, if he brings up I want to see your oath. Is your oath, you just have to sweep it aside and say, sir, that's not here today. If you have any questions, I'm sure you know how to do the research because you told me that you have made sure that you have the competence and the skills of an attorney, of a licensed attorney. So use it that way, but that's it. And you just keep them that way. They are looking. Now, this is a very sad subject that I have found out about these sovereign citizens. And their goal, mainly with the cop on the beat, the officer who's arresting them, but it also happens in court too. I've seen it 50 times on YouTube. Is their goal is to confuse you and make you lose track of what you're doing. And so on purpose, it is not an accident that they just start asking question after question where they are, I see them as very well rehearsed. They've got their plan to stop the court from working really down to a science. But the better they do, the worse sentence I'm going to give them. So if I think that they have practiced many, many hours their pattern of, Your Honor, I believe that that the Constitution forbids you from conducting before this court because the Constitution is a corporation and it says all men are corporations, which, it doesn't say anything like that. The Constitution doesn't say that. If you have the time, judges, if you have the time, one of the ways you can put a stake in the heart of these people is just stop it there, try and keep track of each one of the assertions the person has made. Very hard to do. I know they're doing the Gish Gallop, but just pick one or two out and say, Mr. Defendant, you just said that all men are corporations according to the Constitution. Show me where that is, please. Now, he will try to start talking to get you off track and completely turn you towards something else. You don't do that. You don't get off track. You just listen to him and see, is he speaking about what I asked him, or is he trying to turn the subject around to something else? If he's actually trying to answer your question, go ahead. But if he's just trying to mix you up with, well, I think that your oath that you took is not valid, and that's because it's part of the Constitution, and you agreed that you will not be part of the same monetary fund as both the court and the prosecutor. Now, of course, you didn't agree to anything of the sort, and there's no problem with that. But once you open the jar and let this guy start putting these Rubik's Cube of legal topics in front of you, they've got you. And they are experts at throwing you around. I see many of these people that actually are much smarter than the judge and are able to just keep the judge on his back foot, and the judge really looks terrible. But what you have to do is just say, sir, last chance. I'm not going to let you go through this theory you have of being deprived because you are the beneficiary. Now, first you said you're the beneficiary of a trust. Where is that trust, and what is the name of that trust? It is the Huba Huba Werbo Trust. And, okay, then do you have a copy of it so I can see it? I'll file it with the court. The answer is no, there is no trust. They don't have anything they're filing. Okay, so that's a way to stop that. In other words, for each one of these things they cite, Judge, ask them, okay, let me see it. Where is it? Okay, and the point I'm getting to, and this is the good one, you then can ask them if they've read it, which they haven't. They don't know what it is. They've only seen a program on YouTube. That's where they got their lesson from, YouTube and Wikipedia. So you ask them, have you read this, let's say, well, they're going to say they're the beneficiary of the trust. Okay, you're going to say, have you read the trust? What is the name of the trust? Have you read it? Okay, well, and then you can just start peeling them off of the case, because you just say, well, that document is not in front of me, and they always respond with, well, in that case, I'll file it this afternoon. I did file it this morning, but the clerk wouldn't. And you tell them, and this is important, do not do what the guy on TV does and say, well, look right here. Well, you could, okay, file it. I guess if you file it this afternoon, you could bring it. Don't do that. What you do is you say, it is not before the court. If it's not before the court, do not use it as any supporting of your proposition. And therefore, I'm going to, if this is you, sir, are you admitting that this is you? Any motions you have are denied because you didn't put your documents before the court. And don't teach them how to file documents. Don't teach them how to serve documents. It's not your job to do that. The biggest mistake that I see the judges do is falling for the ridiculous assertion that these litigants say, I have a right to know, the Constitution says, I have a right to know the charges before me. And they will say that over and over. And it doesn't matter if you read them the charges, they just say it again. But you have to stop them. And you have to say, the Constitution does not say you have the right to stop the court and demand the judge at your leisure, sir, recite to you the charges. Sir, do you have any, and this is where you have to go into this defense. Sir, do you have any supporting points and authorities that say you have a right to have the judge recite the charges to you? Now, he will not know that what he's got the right to is to know the charges. Okay, that's fine. But there is a world of difference between knowing the charges, which he has a right to know, and if he's been given a copy of the complaint, that ship has sailed. That's over. So you can just, if you're a really nice person, say, sir, there is no right of which I'm aware for you to stop the court and demand to be given and he'll say, well, I have a right to know under the Constitution. And you say, no, you have a right to have been furnished that information, and my records show you have been furnished, and so if you interrupt the court again asking for the same information, you will be held in contempt. And this goes back to what I told you about, you bring in the argument here about you told them they would be held to the level of an actual practicing attorney. And you have to, at this point, you bring it up again and say, sir, do you remember you promised me that you would be as competent as an attorney when you litigated this case? Yes, I did. Do you think if an attorney were here and it was his or her case, they would not know what the charges are against him? No, I don't think that. Well then, sir, if you make one more request for information that I've already provided you, I am going to assume that you are doing it just to be petulant. And if you do that, I will assume that it is just some sort of display on your part that you're trying to get us off the track. And I absolutely will cite you for contempt, and I may issue the contempt citation right then, or I may, if I decide that it's more appropriate depending on the facts of the case, I may set a date and say, okay, next week or something, we are going to have a hearing where I will decide, are you in contempt, and what is the punishment therefore. But sir, and this is I would say the fourth one that I think is as important as the other three, but try and get this one in too, and get them on the record, and have your clerk punch them out so that you've got all of these right there anytime that you need to look at them. And you're going to say, sir, do you remember that you promised me you would be in the same competence and you would know the rules just like a practicing attorney? Oh, God, yeah, I guess I did. Well, sir, then you do know the rules about what does it implicate if I tell you my ruling on a matter and you just start arguing again. Do you know what happens in that case to an attorney? Well, I'm not an attorney. How would I be supposed to? You, sir, you promised me that you would be up to the level of competence of an attorney. You said you would do that in order to get me to grant you permission, which I did, for you to act as your own attorney. So, sir, do you know what is implicated or what the punishment is for an attorney who, when he is given the ruling, instead of accepting it, starts arguing? Do you know what the punishment is? You're held in contempt, and the judge can give you any kind of jail sentence that the local statutes of contempt authorize. So I can hold you in contempt when I rule and you start arguing with me about the ruling. And so far, I haven't seen anything I've ruled on that you didn't argue. So I can see the plane's getting ready to land. So thank you, everybody, for listening. If you would, there are a lot of judges that are going to need this because, unfortunately, the purpose, the goal of these people is to destroy our current legal system, which you can only do by destroying our current political system. So they are looking to destroy our democracy and our presidency and our legal openness. That's the big thing about our country, and put it back into one where they can storm the courthouse and kill the vice president if he doesn't do what they think he should do. So we do not want these people taking over the country, and that is why I'm coming out of retirement. Yes, I am. And I'm going to ask to go back on the bench, and if they're nice to me, they will put me back on the bench, and I will just handle, and I'm going to actually ask that other judges send me the cases, just not publicly, no one will know, but the other judges, when they get somebody up there who starts to go on and on about I'm going to be a sovereign citizen, or I'm going to be a Moroccan citizen, or no, I'm not a sovereign citizen, but I am a man who's living, and as a living man, I have the right to have my own laws, which is just insanity. That's what crazy people say. You know, if I had my way, just the utterances of those words, when the person is under oath, so we know they're not kidding, would be enough to put them in a mental hospital. So make sure that the judges get a chance to hear this. We'll tighten it up into an actual listing of right now it's 12, it could go up to 18 different tactics by which we will dispense with these people. And so share this, hit the share button and let your friends know about it. Hit the bell so that I will immediately let you know when the next episode comes out, which I can tell you is going to be next Monday. And you can, if you would be nice enough to give me a thumbs up if you got anything out of it. And hit the bell, thumbs up, and I will see you next week at Monday at right about 6 o'clock. And not next Monday, which is 9 days away. But the Monday after that, we will be answering your questions because I've got about 50 of them and they are so good. They're better than I could have come up with. So we'll see you next Monday and just subscribe where it says subscribe, please, because that gets my numbers up in the ratings and that gets more people exposed to the show. Please also ring the bell and give me a thumbs up. And I will talk to you soon. Thank you for listening. This has been Judge Not, and we'll see you next week.